Hello everyone, and welcome to today's webinar, which looks at the incoming GDPR regulation and focuses specifically on the challenges in achieving compliance within local government. My name is Simon Merrick, and I lead Agilisys' GDPR and cybersecurity advisory practice. And I'm excited to be co-hosting this second webinar in our series of 3 with Alan Calder, who's CEO and founder of our partner IT Governance. Alan, hello.
Hi, Simon. So yes, I'm I'm the CEO of IT Governance, folks. My background in information security and data security goes back to the late 1990s. The company I led then was the first certified to what is now ISO 27001, and over the course of developing the business IT governance, which is effectively a one-stop shop for everything that an organization might need to tackle its wide range of compliance challenges. We've also become the market leader in GDPR products and training, and increasingly in the world of consultancy across a very broad range of organizations. And we're very happy to be partnering with Agilisys in helping the public sector tackle the significant issues that GDPR brings. Simon.
So, and just a bit about Agilisys. We are a transformation specialist primarily within local government, and through our transformation services division, we provide accredited GDPR support, and we work with IT governance to provide one-stop shop. But actually, it's our understanding of local government and how it works that creates, we think, the real environment for thinking differently and ultimately delivering the positive change that is the spirit really of the GDPR. And our take on the regulation is that it, along with cybersecurity, is an opportunity to make engagement with service users easier, more secure and transparent. And it's about doing the right thing. And on this webinar, we're going to pick out some of the pitfalls and the challenges to be aware of in achieving GDPR compliance. Before I hand over to Alan just to go through this, just to let you know the webinar is being recorded. It will be available for download shortly afterwards, so you'll be able to share this with your colleagues and networks afterwards. Attendees are going to be muted during the session, but if you've got any questions during the webinar, please feel free to type them into the questions function. There's a function on the panel, and at the end of the session, Alan and myself will get through to answer your questions. Any that we can't get through, we'll answer them offline. We've also added some self-help information where you can go if you think your organisation needs help complying with GDPR. And of course, I'll be pleased to assist if you want to talk through any of your plans or challenges. So, Alan, would you be able to walk us through the agenda here?
Yes, of course. So we're going to look at the regulatory landscape and the GDPR territorial scope. Of course, it applies to organizations across Europe, and we'll begin to look at how this affects, in particular, the public sector. Breach notification procedures and key changes in there will be less of a shock to the public sector in the UK than they are to the private sector, who's largely been able to avoid or ignore the need to report breaches to the ICO. The challenges faced by local governments in achieving GDPR compliance, and they are significant, not least because of the complexity of local government organizations and structures, and the practicalities of implementing a GDPR compliance program. Those are the areas we're going to be talking about, and starting with the current regulatory landscape and the territorial scope of GDPR. The General Data Protection Regulation is a law. It comes into force exactly as written across the whole of the European Union. The law does have within it some specific derogations which allow for allow member states to make particular decisions in particular areas. But broadly speaking, it's the same law for the whole of the European Union. And it comes into effect on the 25th of May 2018. We're now somewhat more than halfway through the transition period. The law was passed in May 2016 with a 2-year lead-in to the point at which it bites. And essentially what the law is doing is making sure that all data controllers across the European Union have to perform in exactly the same way and looking after the data of data subjects, and in terms of making sure that all data data subjects, wherever they might be inside the European Union, have the same rights. The way the Data Protection Directive was implemented meant that because it's a directive, member states were in a position to do more than the directive required, and that led to a situation under which there were significant variations from a data subject perspective between, say, Germany and Holland, perhaps at one end, and the UK and perhaps Portugal at the other end, in terms of the rigor with which the legislation was developed and enforced. That makes life very difficult for data subjects, also makes life very difficult for organizations trading across Europe. Of course, in the UK, the public sector has been under an administrative edict to report data breaches, and there have been specific requirements about information security, which have been, in a way, much more transparent than have been applied to the private sector. And so, from a public sector point of view, you might think that this is going to even up the playing field a little bit between the public, the private, and the third sector, but nevertheless, it's a significant shift even for the public sector. The territorial scope is it applies to any organization that's based inside the European Union, irrespective of where the data subjects live or their nationality, and it applies to organizations, controllers, or processes outside the European Union, but providing services into the European Union. So if, as an organization, you were drawing on services or outsourcing services somewhere else in the world, that organization outside the UK would have to comply with GDPR. So the geographic scope, in effect, is virtually global. In practical terms, it's the data of anybody that is alive. That's the material scope of GDPR. It must be a living person, and living people have the right to protection of their data, to protection of the processing of that data, and to unrestricted movement of that data within the European Union. Any data that's going to be part of a structured filing system, or which is processed wholly or partly by automated means, is caught by GDPR, and that means, of course, that paper records are caught. Anything, CVs, employment history, details about residence, anything which is captured on paper is just as much subject to GDPR as anything which is processed by automated means. So it's a very wide-ranging and comprehensive regulation in terms of its reach. Data subjects have rights, and they're not just the rights to have their data protected, but they have the right to bring an action to seek judicial remedy where they feel that their rights have been transgressed, and they can bring that either where they live or where they think that the transgression has occurred. Not only that, they can bring an action, they can seek compensation where they think they suffered material or non-material damage. They've got the right to receive compensation, which is uncapped from the controller or processor. And as in the public sector, certainly, you know, non-material damage includes the sense of upset, depression, and whatever that somebody can demonstrate by means of a doctor's certificate they've suffered as a result of whatever has happened to their data. So there is a strong possibility, we think, of significant numbers of lawsuits being brought by data subjects who think they've got grounds to seek compensation, and controllers and processors, both in the public and private sector, will need to be gearing up to deal with what we think is potentially a very significant level of activity, which might be supported by trade unions or by lawyers, and to make sure that you handle them. It's not so much the possibility of having to pay compensation, but even more than that, the cost of having to manage all of those activities that one needs to be thinking about. So the remedies for data subjects are very substantial in terms of the range of possibilities and in terms of the impact on organizations. In addition, there are administrative fines, and it's the administrative fines that have been most in the headlines, and the There is in GDPR a tariff, if you like. There's a lower level set of breaches which attract fines up to 10 million euros or 2% of total turnover, or for the most serious transgressions, 20 million euros or 4% of total turnover. Of course, if as an organization you don't have turnover, and that might be the case where local authorities are concerned, then it's simply going to be the absolute amount up to 20 million or 10 million euros, as the case may be. There is a derogation under Article 83, Clause 7 of GDPR, which says that member states may decide to what extent administrative fines can be imposed on public bodies in that member state. We don't yet know inside the UK the steps the UK government might take to exercise that right. The UK government, remember, has quite a lot of fairly major issues on its mind right now, and although it's said it's committed to GDPR coming into force, it's committed to enforcing it. We haven't yet seen significant progress in terms of taking advantage of derogations. We do see progress on these fronts in other member states, but not yet in the UK. So that is clearly an issue in terms of preparation for public sector organizations. You've got to prepare, I think, on the basis that there may be no steps taken by the UK government and that you may be facing fines. And so you've got to do everything that you can do to get yourself in a position to deal with breaches. So the model roughly under GDPR looks like this. Data subjects have rights when they share their data with us, private or public sector organizations, local government. We're a data controller. We've decided what data we want to collect and what we're going to do with it, and we have duties to the data subjects in response to those rights. And there is pretty well a mirror between the two. We can, if we choose to, go to a third party and ask them to process in some way that data for us, for instance, a payroll bureau. And if we do, we have to contract under GDPR with the processor. The processor has a legal definition and may not legally process data under GDPR without having a legally binding contract in place with the controller that collected it. So that's a significant shift. Local authorities will need to identify any particular circumstances under which you've got data or you're processing data, and you'll need to make sure that you have got appropriate controls in place to protect that data. Data might be moved to a third country. That's absolutely fine. If you do that, again, you need to protect it, and you may collect data from a third party. You may collect it, you may share it with a third party. All of those things are possible, and the organization that is charged with the role of protecting the data is, of course, the Information Commissioner's office. The Information Commissioner has the role of ensuring that the GDPR is enforced consistently across the United Kingdom, and they do that within the context of a set of consistent rules applied by the European Data Protection Board, which is being created out of the Working Party 29, which has been responsible for the creation of GDPR. And the logic of the European Data Protection Board is consistency across the whole of the European Union in terms of the way findings are applied, the way fines are exercised, and so on. So the concept of a level playing field should be extended across the European Union effectively. So we've got something like 10 months left until GDPR comes into force. We think that at the point it comes into force, the level of compliance across the UK and the European Union will be fairly limited, inconsistent application. Different countries are at different states of preparation. Some countries are ahead, others behind. Germany and Holland, for instance, are quite significantly advanced. Portugal is significantly far behind. The UK is reasonably well ahead in terms of its preparation. However, the issue isn't so much the preparation of the supervisory authorities, it's much more the preparation of organizations, and substantial numbers of organizations across the European Union will not yet have completed their migrations. Many won't even have started. Bear in mind, though, that in much of the EU, the current level of data protection directive compliance is significantly better than compliance in the UK. So the gap, even for organizations elsewhere in the European Union that might not have started their program, is much smaller than it is for many organizations in the UK. There are going to be a number of people who feel aggrieved, who've got a new set of rights. They'll want to exercise those rights, and they will be interested in testing how well those rights can be enforced. Cyber breaches are going to go on happening. They're making headline news every single day. Those will go on happening, but suddenly there will be a legal obligation to report data breaches and to report them very quickly. So we expect to see a dramatic increase in the number of reported data breaches. We're not yet clear that all supervisory authorities will have the adequate enforcement or response capabilities to handle them. So it may take some months before we see how that all pans out. The reality is going to be, though, that there is going to be a lot of noise from May next year. There will be enforcement action taking place. There are supervisory authorities who will be looking to make examples of organizations that are not in compliance. We'll be exercising the words in GDPR, which says that administrative fines must be proportionate, effective, and dissuasive. So from a compliance preparation point of view, it makes sense to get started earlier than later. Key changes, as I've already indicated, come around breach notifications. While it's been a requirement in the UK for local authorities in the public sector to notify the Information Commissioner of breaches, it's only been an administrative requirement. It becomes a statutory requirement from May next year. And the requirement is that data controllers have to notify the supervisory authority within 72 hours of first becoming aware of a data breach. And when you consider that most data breaches deliberately occur on a Friday, that means you're reporting to the Information Commissioner on the Monday. And you have to describe the breach, what happened, what you're doing about it, and quite a lot of data, which frankly, if you don't have a pre-rehearsed, pre-tested data breach response plan, it's going to be virtually impossible for you to pull together in the time that you've got. There is no requirement to notify, though, if there is no risk to the rights and freedoms of natural persons, and typically that means because the data that's been breached, for instance, is encrypted, and therefore there is no possibility of it being used or accessed by whoever has stolen it. Failure to report within 72 hours, those carry the lower tariff of fines. Processors, if you've outsourced processing of some activity to a processor, they have to report all breaches, irrespective of size and complexity, to the controller with whom they have a contract, and they have to do that as soon as they're first aware of it. There will be some explanation emerging about what undue delay might mean, but data processors certainly are liable for the security of data only in terms of their compliance with the contract. If they are not complying with the contract, they've got a bigger problem because they're in breach of the law overall. They, remember, are only allowed to process data if they have a contract to do so. So significant changes around data breaches and the reporting of. And a data breach is very widely defined. A data breach is any authorized or unauthorized compromise of the confidentiality, integrity, or availability of personal data. That means accidental. It means somebody sends out some letters by mistake to a wrong address, releases information by mistake, deletes files by mistake. They're all data breaches. They all potentially have to be reported. If there's a high risk to the rights and freedoms of data subjects, the controller also has to tell the data subjects, and you've got to tell them very fast. And that typically is within 72 hours. You've got to tell them in clear and plain language. You've got to talk to them directly. Bit of a problem if your own records are not up to date. That's yet another area to find yourself being fined for. But you need to communicate. You have to give, as quickly as possible, data subjects an opportunity to protect themselves. The only way you can exempt yourself from having to tell data subjects being breached, as I said, first of all, there is not a high risk, or if there is a high risk, it won't materialize. There's a disproportionate effort involved in communicating individually, which means you can communicate across social media or in the news, and you've taken appropriate technical and organizational measures to limit the impact. So a big challenge, and again, particularly for local government processing lots of personal information, very large numbers of data, sensitive categories of data, special categories of data, and the challenges around ensuring that you've got adequate security that might mean you're not going to be breached. And frankly, when you look at the range of breaches which occur, there is quite a lot to worry about. So Ipsos Mori's most recent cybersecurity breaches poll identifies that 72% of breaches originate from fraudulent emails or people going onto fraudulent websites. In other words, they are staff-level breaches. Viruses, spyware, and malware is 33%. Others impersonating organizations in emails, so CEO fraud, all of those kinds of frauds, man-in-the-middle type attacks. So it's not just about technical security, it's also about personnel training, it's about procedure, it's about how you manage when there is a breach, how you manage the rollout of the breach and the response to the breach. They're all part of ensuring that you can deal with the ranges of breach occur. And any one of these that occurs, remember, is going to trigger the need for you to report. We mostly say, and the ex-head of the CIA kind of echoes it, if you don't think you've been breached, that's because you're not paying attention. It's not a question of if you'll be breached, it's only a question of when will you be breached. And when you'll be breached means that you need to be prepared, you need to be able to identify that there's been an incident, you need to have the resilience to respond, you need to be able to deal with all of that. Being able to demonstrate that you're resilient, you planned, you're prepared will be part of the argument you can make to the Information Commissioner that you were in command, you were in control of your situation, you knew you'd be breached, you got a proper response process in place. So standards like ISO 27001, 22301, PCI DSS, all of which contain elements that deal with data breach and incident response are really good ways to structure and formulate your approach to dealing with breaches. And looking at breaches, given that breaches is the way you get yourself into trouble, avoiding breaches is the way you keep out of trouble. So thinking about avoiding breaches starts with improving governance around data breaches, top management accountability, having a chief information security officer who owns not just security but also business continuity. That should be part of an integrated set of activities. Monitor readiness at the top management level, make sure you've got proper oversight of how data is being protected. You've got an obligation to have a data protection officer in any case. Make sure your DPO is not just a lawyer, they've got the breadth of knowledge and understanding which enables them to deal with the range of information security challenges that come with protecting data. Test your response plans, make sure you've got appropriate assurance and certification frameworks that can demonstrate you're in control of what you're doing. That's the first step. The second step is to make sure that your platform, if you like, your security platform, how your security practices operate, how well people understand what they should be doing, making sure your systems are patched, operating systems are upgraded, you've got proper device configuration policies. All of that's should become an important part of ongoing platform security. Test your infrastructure. Internal and external penetration tests should make sure that there are no opportunities available for attackers to get in. Encrypt data, personal data, sensitive information, keep your technology up to date, keep staff trained, particularly in light of emerging threats such as ransomware and so on. A number of key actions that any local government organization should be taking today, not just to prepare for GDPR, but to make sure that you don't suffer the kind of debilitating damage which occurred. There have been local authorities who've had to send people home for a week because they've been unable to counter the deployment of ransomware across the organization, for instance. So, challenges faced by local governments in terms of achieving GDPR compliance. Simon, I think I'm going to hand over to you here.
Yeah, thank you. So the local authorities I've spoken to generally cite two practical challenges that they have with the compliance, and one is just around the programme generally, and the other element is the legalities and dealing with all the legalities of the regulation and interpreting them. So we're going to cover some more of the legal elements, but first we'll talk about the challenges that you're going to need to address in running the compliance programme. The Data Protection Act has been around for many years, and I'll say all organisations should be fully compliant. I'm sure they are, but we all know that compliance processes, they get dusty, they get left on shelves, unloved, unused. The world's changed around them, and authorities really need to be considering GDPR as a change programme. It's not a compliance programme on its own, and I don't think everyone gets that. Not everyone gets the importance of data protection. See, you're on this webinar, you do. I'm sure your head of legal gets it in their own special way, but the CEO is probably focused on council housing. The IT manager's looking at you with that book that says exactly which hand would you like me to juggle that ball with, or maybe they're thinking let's just wait and see. There's no silver bullet here. It can help to have some independent size nines and an organisation to help get that attention if that is the problem. Dedicated planning and implementation resource, not employing the right balance of skills and talent, and falling into that trap of thinking you can move an existing employee into the DPO role and give them a training course and we're all good to go. For local government particularly, you'll need a blend of skills across data protection, change management, IT, and privacy analysts who really understand your organisation and industry. You're going to want to make sure that the DPO has got sufficient support and is crystal clear on those responsibilities and role boundaries with the likes of the information security manager and legal. Financial budget, there's just never enough money, is there, in local government? It's always going to be a challenge to make sure you've got sufficient budget. But I think without really establishing a clear scope of your GDPR compliance programme, it means that you're going to be setting false expectations, and you're probably going to have to go back to the table for more budget. So setting this budget requirement early and clearly, and also setting it against the potential fines, and with a mindset that you just need to do the right thing by your service users, you will have a compelling case here. Determine who is the processor or the controller. Alan touched on this. If you've outsourced IT and platforms to third parties who themselves hopefully are considering GDPR, again, you need to be crystal clear on who is taking what role for a particular data set. Who's the processor here, who's the controller? Because if you are the controller, you are responsible for making clear the processing requirements to your processor. And if it all goes wrong, you can imagine the processor who is now going to be potentially on the line for fines if they're found to be liable. They're going to be scrutinising that contract that you've written with them. And local governments are probably one of the most complex organisations that we have. Often many of them have 400 to 600 different services. So the interchange of personal data between the services is going to require some fairly beefy analysis. And you may want to look at some mapping tools. There are some quite decent graphical mapping tools that are coming to the market now. But remember, whilst you've got to do an audit here to get started, this is quite rightly, it's an ongoing requirement. You should be taking care of and monitoring all that personal information that's going to be traversing across your organisation. We've touched on third parties. Again, clarity with your processes about what you expect from them if they are using third parties. So if you've documented that you've done some due diligence with your processes about what third parties they might be using, it's all evidence. If something does go wrong, at least you can demonstrate to the ICO and supervising authority that you have looked to do the investigation and you've done that due diligence. If we just move on to the next slide here. So spending too much time on doing the audit, it is important, but just forgetting whilst you're while you're doing this and missing the obvious, whoever is sponsoring the compliance needs to, on one level, to be clear that you're doing this because it's the right thing, who's the caretaker for service users' personal data. But on the other level, you've got to protect that data from attack and malicious intent. And I think conveying that to people will help them get it. And also it'll help them when they do the audit, identify those documents that are sitting on someone's personal network drive. We talk about CVs, that will have personal data that may be on someone's personal drive because they were doing the interview. You still need to hold it. Audits are great, but they're just a snapshot. Don't forget your shadow IT, those good people who set up a website on their own because IT were too slow or didn't get around to it, or perhaps rented server space from rack space to do their own website, or using unsecured personal devices. As we talked about, human error here causes a big majority of the data breaches. And human error is probably the most exasperating bit, really, because it's the most preventable. So the employees leaving their laptop in a car, paper files being left around, employee mistakenly email sensitive information outside. It's easily done, but it's got to be addressed. I think also if you send out a questionnaire to people about what data they process, just be careful that you're giving some guidance around it, that people actually understand what this is about. Otherwise, you're going to miss a potential vulnerability or risk area. Be firm and clear with your suppliers, review the contracts, audit your suppliers to make sure they're doing GDPR compliance work to where it relates to your exposure to them. It's just, you've got to get the commercials right, you've got to revisit the commercials, and you're going to need your legal people involved with doing this. Funding and booking your IT resources. I know from my own experience, if you don't get them booked in, if you've got to make changes and you don't get them booked in early, they've got other things on their schedule, and you're at risk of them saying, no, we can't do this until the next summer. Leaving it to your legal people. I'll tread carefully here in case there's any legal people on this on the webinar. I love legal people. My dad was a solicitor, and I believe GDPR is going to create many legal conundrums and work for those legal people. But it's a double-edged sword here. If you don't engage legal sufficiently in terms of how they work with the DPO, it means that there's an opportunity to fail against the 50+ different areas of compliance here. And if you leave it all to them to pick up the risk, I think there's then you miss the transformation opportunity here. One last point I just wanted to make before we go, it's just it's a bit of an odd one, but if you go against the advice of your DPO, so they are meant to be independent, but they may make recommendations that the board think it's not the right time to make the investment, or they don't agree with the assessment, and that is going to be the right of the organisation to make that assessment of the risk that's put in front of them. The key thing I'll be saying here is make sure it's documented and that you've got your evidence about why you took that decision. As I say, money is not unlimited, and you may have to schedule some of your investments going forwards. So one of those decisions that you're going to have to make is around the lawful basis of processing. So Alan, I wonder if you could just walk us through this one.
Yeah, so the requirement under GDPR is that you have to have a lawful basis for processing data. The range of possible lawful bases are set out in Article 6 of GDPR, and you have to meet at least one of them, and from a simplistic point of view, preferably only one of them in respect of each element of data that you're processing. And the range of options starts with consent, continues to include, for instance, in order to deliver under a contract that you have with the data subject, include legitimate interests and so on. And you have to identify at the point that you first collect the data what the lawful basis is for processing it, and you have to make sure that you've told the data subject what you see the lawful basis is and how you're going to deal with it. On the right-hand side of the screen, you can see the list of the 6 lawful bases that Article 6 provides. What are called special categories of data. We think of those as being data covering, for instance, health, gender, sexual preference, biometric data, genetic data. All of that kind of data is prohibited from being processed unless you've got you can meet one of the additional conditions set out in Article 9. So for special categories of data, you have to have an Article 6 lawful basis of processing, plus you have to be able to identify an Article 9 exception. You can't then use the data in ways that are different from the lawful basis you've identified. You have to be transparent about how you do it. You should be only using data in ways that people would reasonably expect, and you have to make sure that data is not being handled unlawfully. And broadly speaking, local government will be doing most of that right now. You've spent quite a lot of time over the years making sure that those kind of elements are in place. But The definition of consent includes the requirement that consent must be freely given, and that makes it quite difficult for both employers and public authorities to rely on consent, because the position of a public authority in relation to citizens in its area or residents in its area is just like that of an employer to its employees. It's got disproportionate level of power and authority. It's not therefore possible for the data subject to freely give consent or to freely withdraw it, and the right to withdraw consent is automatic if consent is the basis on which data is processed. And that means that for most organizations, the lawful basis of processing shouldn't be consent. For employees, it's going to be a mix of, depending on which elements of data, in order to fulfill a contract is likely to be one lawful basis. But mostly you're going to switch to the lawful basis called processing for a task in the public interest. And many of the tasks of local authorities will be in the public interest. And you need to tell data subjects what the lawful basis is, and you're certainly going to need to make sure that the link between your Article 6 lawful basis and the exceptions around special categories of data are carefully thought out. And it's a key area where local governments need to be talking with their lawyers and with the Information Commissioner as soon as possible, because the work of implementing whatever you decide to do is going to be significantly time consuming. Data subjects, as I've said already, have rights, and the requirements around rights are set out in Article 12, and essentially the law says that data controllers must facilitate the exercise by data subjects of their rights. That means make it easy for them, help them, tell them what they are, enable them to understand them. All of that kind of stuff is part of making sure that you facilitated the exercise of their rights. And those rights start with the right to be informed. We've just talked about that, the right to know what you're doing with their data and how you're processing their data, that's contained in your privacy notice, the right of access to understand, to send your data subject access request to know what you're doing with data, the right to have any errors rectified and fixed, the right to have data erased if there's no longer a lawful basis for processing it, and bear in mind that if you've collected data on the basis of consent and consent is proven to be invalid, you don't have a lawful basis for processing the data, and so a data subject can require all of that data to be erased. A data subject can restrict processing. They've got a right to get data back from you in a machine readable format, so they can share it with another alternative provider. Both the rights of erasure and portability are limited. They're not absolute rights, and you'll want to get clear about how those limitations work. There's a right to object to processing where typically the lawful basis of processing might, for instance, be legitimate interests. And there's rights in relation to automated decision making, particularly where that decision making has legal or other significant impacts on data subjects. So the rights of data subjects, facilitating them, knowing how you're going to help data subjects deal with them is critical. And the starting point for doing that, of course, is the data subject access request. And again, most local government entities will already have a working subject access request process. The DSAR is simply an extension of that, and typically it might be a written request, but GDPR says it no longer needs to be. It can be made orally, it can be made any way that the data subject wants to. So you've got to train people to recognize that. You can't charge them anymore for a DSAR for providing the information they asked for, and you've only got a month. You used to have 40 days, now you've got a month. You don't have to provide the answers in writing. You can provide the answer in the same format as it was given to you. It needs to include archived data if there is archived data. And of course, when you provide data, you need to have redacted it as you do now, so that any information about other individuals is not included in what you share with the data subject. So shouldn't be much news, some significant improvements and tightenings up, but the important thing to bear in mind is that a DSAR becomes the starting point for a data subject who might wish to bring an action against a local authority for material or non-material damages, or indeed anything else. So it shouldn't be seen simply as something you've got to do and do properly. It's something you've got to do as part of avoiding the consequences of an action. Data protection officers have a role. GDPR gives DPOs a legal role for the first time. The role of the DPO is to make sure that the organization adheres to relevant privacy laws and that privacy considerations are taken into account in the design of new processes and practices. Article 39 sets out the tasks of the DPO, and they start with informing and advising, continue through monitoring performance, getting involved in data protection impact assessments, and of course cooperating with supervisory authorities around anything to do with risk to the rights and freedoms of natural persons. And public authorities are required by law to appoint a data protection officer. So local government, central government, anything that falls into the camp of public authority must have a DPO. Now, you don't have to have a DPO for every public authority. An individual, you can share a DPO amongst multiple public authorities. You can contract with an outside organization for DPO as a service, for instance. But whatever it is, your DPO should have the requisite mix of knowledge of the law. GDPR is a law, they have to advise on legal compliance, but the requisite mix of knowledge of the law and practical understanding of how to implement it and the issues involved in implementing it, monitoring compliance with it, and generally making sure that it works effectively. So key role, and the contact details for the DPO must also be published. They must be available to the public and available to the Information Commissioner. So local government has a mandatory requirement to appoint DPOs. There is also a mandatory requirement to carry out data protection impact assessments. And a DPIA is going to apply in much of the public sector's operations. It applies to automated processing, to large-scale processing of special categories of data, and to processing of data in publicly accessible areas. One of those is likely to catch most public authorities to one extent or another. Bear in mind that a DPIA is also a good practice activity. It's the starting point for what GDPR calls data protection by default and by design, the building of data protection into the overall organization and operations of the entity. DPIAs should be part, therefore, of the entity, the local government entity's overall risk management framework, should build on your existing understanding of how to do privacy impact assessments, should feed out into risk treatment plans, should enable you to demonstrate that you've thought properly and systematically about how to protect data subjects, how to protect and preserve the privacy of the people whose data it is that you are dealing with. So GDPR priorities, you should prioritize on the basis of where your threats are. And your threats start, frankly, with data subjects, aggrieved data subjects, seeking compensation, making complaints, and they start with the need to report data breaches. So as I've already said, thinking about data breaches, your priority in terms of GDPRs is simply a wider scale or a broader set of that. Make sure you've got governance right for your authority. Make sure you know what data you're holding, where you're holding it, and make sure that by May next year you have a lawful basis for holding that data. When GDPR comes in, it doesn't say any data you collect from now on has to be collected in line with GDPR. It says any data you're processing on that day has to be in line with GDPR. And processing includes archiving, storing, manipulating, using, and that therefore means all data that the local authority is using on the 25th of May, it needs to have a lawful basis for using, or else it has to stop, because if it goes on, it will be breaking the law. So Identify what archives you've got. Delete or eliminate data archives that are beyond the purpose for which you collected the data. You're, under the Data Protection Act, not supposed to be holding that data. Under the GDPR, holding data for longer than you should do is likely to give rise to administrative fines and to data subject lawsuits. Get your documentation up to date, make sure website privacy notices, notices issued to staff, all of that kind of stuff is brought up to date, is in line with the requirements of GDPR. Update your data subject access request process, bolster your incident detection, response, and data breach reporting processes, and really in parallel make sure that your cybersecurity, hard and soft, technology, people, and process are all up to scratch. You're not going to be compliant, frankly, by the 25th of May. The best you can hope to do if you really get started now is to have made significant progress, and if and when you're breached, to be able to, as part of your mitigating arguments to the Information Commissioner, to be able to say, we have a plan, we're getting on with executing the plan, we can show you what progress we're making, and with a bit of luck, you might be able to use that in mitigation to reduce the size of the fine that will be levied on you. So the practicalities, the reality is that it's tough. You've got to get top management involved. You've got to get it onto the corporate risk register. You've got to get top management and the local government board or management board or council board, as the case may be. You've got to get them committed to the compliance projects. Got to get onto their monthly meeting agendas. It's got to have money allocated to it. It's a significant change project, and you really do want to make sure that you're going to be able to handle it. There's a multi-year budget forecast. You need to have data protection risk in your overall risk management approach. You need a program management team. You need a data protection officer established and a program manager involved, and solid communication to staff and suppliers about what you're doing and why. Get very clear about how you're handling it across the local authority, the local government entity, which entities are in, who owns it, and which divisions. Work out what standards that you can leverage or interface. Work out the dependencies between different parts of the organization. You might have a database which is shared between housing and other parts of the organization, but the data subjects might not know about it. Make sure that any IT projects you currently have underway are early candidates for data protection impact assessment activity. So high-risk databases, start with identifying what those are, make sure that you've got in place a practical way of dealing with those. Deal with the high-risk data flows where high-value data, sensitive data is moving in volumes between different users. Look at the internet-facing IP addresses and URLs and get those all solidly tested, and then, as I say, identify and cull old data archives. Get rid of information that you don't need. If it's archived and you're unable to, there's good guidance from the Information Commissioner on how you can demonstrate that it is, to all intents and purposes, not capable of being used. Good retention policy, demonstrate that you are actually implementing it. Make sure that the security is appropriate to risk. Look at areas like pseudonymization, encryption, how you ensure ongoing confidentiality and integrity of data. Put in place effective PAN organization auditing so that you can test, assess, and evaluate the effectiveness of your data protection. The requirement is that you implement appropriate technical organizational measures, and to be able to demonstrate that your measures are delivering security in a way that you want to, and that means you need a data protection policy inside the organization. Use approved codes of conduct, Cyber Essentials Plus, ISO 27001. Use those all as mechanisms for improving security and for demonstrating that you've taken measures to put in place appropriate technical and organizational measures as GDPR requires. Remember, GDPR doesn't say that your appropriate measures can be, your appropriate measures have to your appropriate measures don't have to be the same across every single local authority. The requirement is that the measures you adopt are in line with and reflect the risk assessment that you've carried out. The risk assessment should take into account the range of risks to the rights and freedoms of data subjects, and the implementation of controls that ISO 27001 gives, for instance, is a way of demonstrating that you've gone through a process which is appropriately structured and which will deliver the result that you want. In practical terms, you can have the most GDPR compliant documentation in the world, and you'll still potentially be in breach of the regulation. So make sure that you're looking not just at documentation, but the practicalities of how you go about achieving proper compliance. Make sure your data protection officer is genuinely in a position to have oversight, maybe sits in top of or as part of a major team sitting inside your compliance team, who are able to oversee, provide advice and guidance across the whole area of activity in relation to GDPR compliance. Make sure they properly understand the DPO. You have a DPO who understands and can articulate data protection by design and by default, and make sure that DPIAs are being carried out where you need them to be carried out. So DPO leadership is a critical part of doing all of this effectively.
Thanks, Alan. So just to summarise, I think where we've gone through here, I think the regulation, it is, I think the word's probably flexible. There's lots of words like appropriate, undue delays. They all need interpretation in your organisation. It's certainly logical to assume there's going to be more breaches by the virtue of certainly greater attention by the media and, well, particularly the hackers, and particularly there's a broad definition of personal data here that's now covered by GDPR. Public authorities, they need to report on breaches already, so there's no change there. It's obviously different for private organisations that now get drawn in here. And of course, with the greater media retentions, more enforcement, you can assume that the ICO and the media will jump aggressively on a breach, especially from a public sector organisation. The fines are bigger, there's more areas to fall foul of, and failing to record processing in is one area. Supporting data protection by design. You know, there's lots of areas here to fall foul of, and it's going to take time. Whilst you can assume the size of the challenge now, you need that hard analysis to prove to your board what the scope of your program needs to look like. Existing infrastructure is going to need reviewing from a security perspective. Contracts need looking at to ensure there's clear obligations between the controller and the processor. And service designs, you know, what do your forms look like, or your websites need to be looked at to make sure they're compliant with the regulation, and also all the associated policies like data retention, where consent's used, how long is consent held for. Finally, it's working with your partners and your processors now. But as controllers, you've got to take the lead. You are going to be accountable. So at the end of this sidebar, we've got some information in here about where you can get help. There's a facility that Justice has with IT governance where you can book training and awareness sessions. We've talked about the importance of understanding what it's all about. You can put that online. And there's also broader support available in terms of books and consulting support, so do get in contact. There's an email at the end of this deck for information on that. Alan, I think we've got a little bit of time for some questions, and let's just pick up one here. I've got here, it says, let me just open up the questions box here. This is our from Rosemary Crampton. Are the mandatory requirements for DPOs and DPIAs for local authorities also mandatory for third-party suppliers?
The answer is that insofar as third-party suppliers might themselves be public authorities, yes. If they are not public authorities, then no, unless they're caught by one of the other sets of requirements. So there is a mandatory requirement that organizations that are processing large volumes of personal data or large volumes of special categories of data have to have a DPO, so private or public sector, you'd be caught by that. And there's a requirement that when introducing new technologies or when processing large numbers of special categories, large numbers of personal data or special categories of data or processing in a public area, that you carry out a DPIA, irrespective of whether you're a public or a private authority. So the answer is it depends on which of those catch you.
Okay. There's another one here, which I've had this from an authority before, but from Andy Chernley's. Article 6.1 states that the legitimate interest provision doesn't apply to public authorities, and we talked through that in the webinar. But so presumably this means that public authorities must have another lawful purpose. Is that correct?
Yes, and typically the lawful purpose would be processing for a task in the public interest.
Okay. There's also, I guess it also affects if you're using data in one particular service to validate or verify data in another service in terms of its use. Is that that's legitimate?
It could indeed. Bear in mind that the fact that you're processing for a task in the public interest doesn't absolve you of the requirement to tell the data subjects what you're doing with their data, and to make sure that they are fully aware of everything that's happening with their data. And the fact that you've collected their data to do one thing doesn't instantly entitle you on that same lawful basis to do something else with it. So you'd have to look at the repeated use of data and determine that this reuse of data itself has a lawful purpose, which might be processing for a task in the public interest, or it might be something else. But each one of those reuses of data in the public sector is going to need to be looked at, an appropriate lawful basis identified, and an appropriate mechanism for talking to the data subject put in place.
Okay. There's an interesting one here about the Network Information Security Directive from Jasvinder, and kind of discuss, is there a correlation between the NIS and GDPR?
It's a good question, and it's a good question because, first of all, the Network and Information Security Directive comes into play on the 8th of May next year, but it's a directive, so member states still have to transpose it into law, and they've got 6 months to identify what falls within the ambit of the Network and Information Security Directive. So that, in a sense, means that there's likely to be a little bit of a transition period, but the government's not paying that much attention to it just yet. Public authorities will almost certainly be caught by the definition of critical national infrastructure. They are at the moment. And so the requirements around information security, cybersecurity, business continuity, auditing, all of the requirements that you already see in GDPR apply under NIS as well. NIS has the same set of penalties, administrative penalties, as does GDPR, the same size and range of them. And the only difference is that under NIS, the application, the scope, is much, much wider than just personal data, because it applies to all of the processing of the local authority. So there is a key intersection, and if you're worrying about GDPR in local government, you should also be beginning to worry about how you're going to overlap your GDPR project with your Network and Information Security Directive project.
So it's going to keep the CISOs and information security managers busy for the next year at least. And some. There's another interesting one here. Hayley Weldon. So where does a local authority who is an administering authority for an arm's length organisation stand with regards to GDPR? Can the ALMO adopt local authorities' processes, or should they have their own protocols in place?
That's a good question, and it's one where I think the only sensible way for me to answer it is to say I think that's a conversation to have directly with the ICO or with your lawyers. There's nothing which sits very clearly or capable of interpretation in GDPR which would give us an insight into what that might look like. Talk to the ICO or to your lawyers.
Okay, and this one here is also a common one that we've seen. So is business information of employees, so business emails, phone number, is that considered to be personal information?
Yes. Anything that enables a human being to be identified is personal data. GDPR doesn't recognize any differentiation between an email address at a company or an employer from an email address in your own private life. They all identify you, and so any organization. So this has implications for, at a simple level, collecting the contact details for the procurement team at a customer or vice versa. That's all personal information you're collecting. It's all caught within the material scope of GDPR.
I guess, and on a practical level, actually managing that and making sure you are compliant, that's quite a big deal. And people are writing emails hundreds a day.
Correct.
Yeah. It's actually raised to other queries I've had around data that's held in backups and storage, and personal data that's just backed up from systems. That's all in scope here, isn't it?
It certainly is.
Yeah. Okay. And just, I think we've got time for one final one here. So it says, where public authorities have spun off functions into limited company structures where they retain a majority shareholding status, recruitment, training, services, how does the obligations reside in regard to GDPR, DPO appointments, controller versus processor obligations?
Well, technically, the obligation exists at the entity level. So if you spun it off into a subsidiary company, it has a legal personality. If the subsidiary company is collecting data, it's a data controller. If it contracts with another entity to do something with that, there has to be a GDPR compliant contract that covers the processing. So that's the first simple way of thinking about it. The second element is thinking about the reality of control. If the reality of control is that the spun-off subsidiary company is actually controlled by the local authority, then it's very likely that a supervisory authority would come down on the controlling entity rather than on the underlying subsidiary in terms of compliance or administrative activity. And that's because, and this has already been a very clear statement made in Germany, who's quite a long way advanced in terms of thinking through these issues, because it recognizes that it's entirely possible for an organization to set up a subsidiary and then to starve it of the resources that it needs to do its job properly. So you should assume that unless the subsidiary entity has all of the power and resources it needs to do what GDPR expects it to do, that supervisors will go after the parent or controlling entity.
Okay, great, thank you. So I think we're just about out of time here, so we need to stop. So I'd just like to say thank you all for your time coming along to this webinar. I hope it's been useful for you. Please don't forget to get in contact if your organisation needs help. Time is running out. And last thing for me to say on behalf of Alan and myself, thank you, and good luck with your GDPR compliance programme. Thank you.
Bye-bye.